I like that zoom, Mr. Aranda. Okay, Mr. Berman, you're up.
All right, thank you, Your Honors. May it please the court. There's one email or two emails that constitute the contract in this case, which really are not the contract, but the terms that would guide preparation of the settlement agreement. The email says his authority was $18,000 to be divided between two agreements, and it was payable within 15 days after approval of the FLSA settlement. Obviously, it was not approved, and we filed suit in state court. We were unable to reallege the EPA claim or FLSA claim in state court because the time had expired. Those claims could not be refiled. In the summary judgment hearing below, the issue was squarely put to the judge about, was there any prejudice to the defendants? And they alleged in their answer expressly at page 309 of the record that failure of a condition precedent was their first affirmative defense. Paragraph 21 of our complaint alleged that my client could not refile because of the statute of limitations. So the issue that where the trial judge erred and should be reversed is in not resolving the issue, and the defendant did not prove its affirmative defense. It didn't offer, despite offering a lot of documents, it didn't show that these claims could be refiled, which I would have done if they could. So there's no prejudice.
I'm sorry, help me understand that argument a little bit better, Mr. Berman. I think I just heard you say that they failed, Hydraulic Hose failed to prove that
An affirmative defense.
The affirmative defense of the failure of the condition precedent, but there's no dispute that Judge Merriday never entered an order approving the FLSA settlement, and there's no dispute that he subsequently entered an order stating that case can't be reopened at this point. So, I mean, I'm not sure if this is a condition precedent or if it's a dependent covenant, but whatever it is, it can't happen. It's not going to occur. That's not really disputed, is it?
No, it's undisputed that the case was dismissed without prejudice in federal court.
Okay, which means that it couldn't be approved. The settlement could not be approved.
After 60 days, the period to approve was vanquished. The question now is, was that, even though it's a condition of payment, have they been prejudiced? Because settlement agreements are governed by the law of contracts. So now my whole argument is about the law of contracts and was there prejudice to the defendants from the lack of court approval. And for my authority is the Deutsche Bank case decided by the second DCA, 203 Southern 2nd, 918, footnote 5 says that there has to be some prejudice if there was a failure of a condition precedent. In other words, they don't get dismissal without prejudice, but if the SOL has run, they've gotten the functional equivalent of a dismissal with prejudice. And they also could have had a full and complete release for the EPA claim. That was not governed by a 60-day provision. That did not require court approval. And then the other issue is who was responsible for obtaining court approval. If you look at the email, it doesn't say who's doing what. It wasn't until 4 minutes later that Mr. Aranda thought about, well, who's going to do what? And he said, please draft a motion to approve, and I will draft the settlement agreement and then provide it to you within a week. And that never happened. So this forfeiture ordered by Judge Stoddard should be reversed. At minimum, minimum, if a party wants forfeiture, and if those drafting commitments are part of the contract, then the defendants breach the contract as well, and you cannot insist on forfeiture if you yourself have breached the contract. But my contention is that they're not part of the contract. The contract is...
That argument sounds more like an equitable argument, or more an argument, and hey, this just isn't fair, which usually is something we would consider, or a trial court, I should say, would consider, as far as like maybe an unjust enrichment claim. Which
we have, which I'll rest on my brief on that, but it's the restatement second of contracts, Judge Lucas, 2253, it's cited in our reply brief, and that essentially says, if a condition precedent is not met.
I'm not sure this is a condition precedent.
I think
it reads more like a dependent covenant. I get it that there is a third party that's involved, the federal court, but I mean, it's just clearly somebody's going to do something and send it over here to get approval, and then once that happens, then you get $18,000, which looks to me like a dependent covenant. Which ends you up in the same place, which is that it didn't happen.
But the idea that, first of all, in construing whether this is a dependent covenant or condition precedent, you still have to construe it in a light most favorable to the plaintiff. You have to, again, this is summary judgment. We don't have an actual agreement that was drafted within a week. I would have objected to any forfeiture clause. So we're sort of speculating about what the eventual settlement would have looked like if it were drafted. It would not have provided, in my opinion, any forfeiture clause, because that's what's happened in this case. Judge Stoddard said there's no duty to make payment because there was not court approval on one part of the settlement. And if it's not a condition precedent, but rather a formality, then you have to look at, if my side breached, was it material? Did it prejudice the other side? Do they have the equivalent of what Judge Meriday could have approved? And namely, we cannot refile FLSA claims or EPA claims. And that's a factual dispute that they would have to resolve or show no dispute in the summary judgment proceeding. They filed the affirmative defense. They have to prove it. They did not want Judge Stoddard to see the complaint filed in federal court, because that would make it very clear and bare that they have not been prejudiced by the lack of court approval. And that's really requires reversal. It remains to be litigated below, is there prejudice to the other side? It's not like the end result was getting court approval from Judge Meriday. They wanted an end to the lawsuit. They wanted a release of every claim that they could get. And that's what essentially we were prepared to do. But going back to the restatement second of contracts, which says basically a failure to fulfill a condition does not breach a contract unless a party has the affirmative duty that the condition occur. Why is this my responsibility when Mr. Aranda could have submitted something and said, Judge, we want this approval? It seems, why is the risk of forfeiture solely on the plaintiff rather than on the party who drafted the email that did not allocate the burden to get approval on me?
Can you help me there's an assumption in your argument that the expiration of a statute of limitation is the identical equivalent of a forfeiture, which has a unique meaning in law. Is there case law that holds, yes, the expiration of statute of limitation is a forfeiture?
Well, it's the functional equivalent of a dismissal with prejudice.
I understand what happens when a statute of limitations is run, when a statute of limitations defense is successful. I'm asking you, has any court ever held that expiration of a statute of limitation is the equivalent of a legal forfeiture.
A forfeiture of what, Your Honor?
Of the argument that you're making. You are the one that is arguing that this constitutes a forfeiture. I'm asking you, is there a court opinion or a case that has ever held, yes, when a statute of limitation expires, that is the equivalent of a forfeiture?
Yes.
Okay,
Florida
what case?
does not have the savings statute that allows you to refile a claim after it's been dismissed without prejudice and the statute of limitations has expired. That's either.
Let me help you. Are you asking us so to hold?
I'm asking you to hold that they have not been prejudiced, or they did not demonstrate any prejudice from the lack of court approval. And I'm asking you to determine that because the agreement, the email is silent as to who was supposed to do what, that is another ground. Any ambiguity would be resolved against the company or the defendants.
So your position basically is that the issue of prejudice is a requirement for them to prevail, and
Yes, Your Honor.
and that is an undisputed issue of material fact below because there was no showing.
Correct. They made no showing that there was any prejudice. They've gotten everything they ever wanted. She was no longer employed as of when we refiled for more than 3.5, 4 years. She could never sue them on anything again. I would say one thing about Judge Meriday's decision. He did take a shot at me and said, it looks like it's carelessness. The standard to vacate under Rule 60 in federal court is extraordinary circumstances, which didn't exist. This was preventable, no question, less than stellar, but we still have to go back to Florida contract law and the duty of the defendant to show prejudice exists in the second DCA, the Deutsche Bank case I mentioned, also the Allstate Floridian case. And those are not just, quote, insurance cases, because all of those insurance cases are applying general contract law. For example, if someone doesn't submit a timely notice of claim, but the insurance company is not prejudiced, then there's no forfeiture of coverage. And I think that goes back to one of the things we learned in law school is that a immaterial breach by one party does not relieve the other party of a duty to perform. So the materiality of my failure, alleged failure to obtain court approval, in our view, is not material. That needs to be litigated. I would say the burden of clear expression applies when you're seeking a forfeiture, and we don't have clear expression in the email. If anything, that should be construed as what's called a payment provision, and that comes up when the general contractor says, I can't pay you, subcontractor, because the owner didn't pay me. The Supreme Court, Florida Supreme Court, has held those provisions are a deadline for payment provisions, and they must be construed against a drafter so that the general contractor can't say, the owner didn't pay me, so therefore I have no duty to pay you, Mr. Subcontractor. So I think the burden of clear expression is lacking. It is true. They wanted a dismissal with prejudice, and normally they would have gotten that. But now the question is, under contract law, is the forfeiture sustainable, or does it require something more than the non-occurrence of court approval? And can there be a severance of the EPA claim and some allocation made to that claim? Because that claim did not require any court approval to execute a release within or without the 60-day period. We could release the EPA claim beyond the 60-day period. So part of the issue in this case is because of the federal procedural rules, but that doesn't become incorporated into Florida contract law. I'll reserve the balance of my time. I don't know what I have left.
You have just about 5 minutes, Mr. Berman.
Thank you, Your Honor.
Thank you. Mr. Aranda, you up? You need to unmute, sir. I do that constantly.
You just got to hit that little microphone icon.
In here.
Yeah. Down at the bottom of the Zoom screen with the bottom left, there's a microphone. Oh.
Uh-oh.
We're going to get a message now.
This will be a
This
first.
could be a long argument.
Yeah, really. This is what's called a written argument. Oh,
Anybody read it?
not working.
Oh, no.
Uh,
Okay. Your button's not working. Try your space bar and see if that'll toggle it. Oh, there you
Can
are.
you hear me now?
There
Now
we
we can hear you.
My apologies to the court.
No problem. It's
Happens to the best of us.
Yes,
We're in a brave new world here.
yes, sir, we are. May it please the court, Robert Aranda for hydraulic hose and Mr. O'Donnell. The settlement offer that was made, as reflected in the record on page 18, was as follows. My only authority is $18,000 payable within 15 days of the court's approval of the FLSA settlement. The FLA settlement was not approved by Judge Meriday or the federal court. Whether a condition precedent or a dependent covenant, it remains the same. In the absence of court approval, none of the $18,000 was going to be payable. That was the offer that was made. That was the offer that was accepted. Count one of the complaint is for breach of contract. Breach of contract requires the plaintiff to prove that all the terms of the contract were performed so that payment on behalf of the other party is required. The conditions of the contract, court approval of the FLSA claim never occurred, and therefore summary judgment on the breach of contract claim was appropriate. The condition precedent or dependent covenant did not occur. The same would be for the claims for unjust enrichment or promissory estoppel. For a claim of unjust enrichment, which was addressed by the court, there had to be a benefit conferred upon the defendant. And the defendant, in this case, hydraulic hose and or Mr. O'Donnell, didn't receive the dismissal with prejudice, otherwise the court approval of the FLSA claim.
Well, on the unjust enrichment point, I think what Mr. Berman's brief argues, if I read it right, is that, look, you're getting effectively shielded from any further liability. Because the statute of limitations is now run, this case cannot be refiled anymore. You're good. I think that's what they're saying, is that, look, that is a benefit that you got, and you would not have gotten it had we not, I guess the benefit would be, had we not filed this notice of settlement with the federal district court.
My response, Your Honor, would be that my client at that time was still subject to litigation, as both the Lynn court case and the Dees case talking about FLA settlement says. Mm-hmm. Unless you get the Department of Labor or the federal district court to approve your FLSA claim, any private settlement that occurs is unenforceable. So if my client, in the absence of a court approval of the FLSA claim, had paid the $18,000, it would still be subject to some type of other lawsuits. For instance, a claim for breach of contract in the employment context carries a 5-year statute of limitations. A claim for minimum wage under Florida law is either 4 years or 5 years if it's found willful. And at the time that this all occurred, which is August or in October of 2017, those statutes of limitations had not run. So there would have still been litigation that my clients would have been subjected to, for which, if filed, my clients would not have been able to raise payment. Hey, we paid X amount as part of this litigation. They may have been able to raise other defenses, but the defense of I've paid you $18,000 would not have been able to have been raised because, as Lynn and the D's court cases tell us, as it relates to FLSA claims, in the absence of court approval, you have an unenforceable agreement.
Well, I think the other side to that too is that, look, it's one thing to say, well, now you have a statute of limitations defense, you're good. Of course, you have to prove that up, versus, hey, I have a dismissal with prejudice of this exact issue and a court approved dismissal with prejudice, and that's bulletproof, I guess.
Yes, sir. That's the other side of the coin I was trying to argue. It gives us, that is what was being negotiated. That was the material term, whether it's a contract claim, unjust enrichment claim, or a promissory estoppel. It was very clear, payment of $18,000 upon court approval of the FLA settlement. That never occurred in this particular case, and therefore a claim under either of those three causes of action can't lay against either Hydraulic Codes or Mr. O'Donnell. I will point out, because it bears referencing, because it was brought up as to, well, who should have filed the motion to approve? If you'll recall, within 2 minutes, an email said, go ahead and file the motion to approve, and plaintiff's counsel said agreed. And then on, I believe it was a few days later, plaintiff filed with the federal district court a notice of settlement, and this is found on record 86, that the undersigned hereby notifies the parties have reached a settlement of the case, and a motion for approval of the settlement of the FLS claim will be filed within 14 days. So it's clear from the plaintiff's filing in the federal district court that they were taking on that responsibility. And it makes sense, because an approval of an FLSA claim requires the plaintiff to, because it's not a rubber stamp, requires the plaintiff to show that they are getting full value for their wage claim, for their overtime claim. It requires proof and acceptance of reasonableness of attorney's fees, things that the defendant would have no control over. So as a practical matter, it's why the motion to enforce is filed by the plaintiff. As a practical matter, plaintiff represented to the court that it would do it within 14 days. And then when Judge Meriday issued its order that said, I'll dismiss this without prejudice, 60 days to get your Lynn motion to approve in, I want to point out to the court, because this is not a gotcha moment under any circumstances. On 3 separate occasions within the 60 days, I wrote plaintiff's counsel and asked, hey, where are we on the motion to approve? With the second of the 3 emails being very forthright and saying, there's no payment until that's done. And those 3 reminders and requests occurred inside the 60-day period, and with no response back. So the issue has been brought up of the Hydraulic Codes and or Mr. O'Donnell's burden to prove prejudice. I don't think that it is our burden to prove prejudice. The affirmative defense was, it may not even have been an affirmative defense. You haven't proved the elements of your claim for breach of contract, which is that all the elements necessary to get the $18,000 occurred for approval of the settlement. In the absence of that, the trial court's ruling granting summary judgment and entering final judgment on all 4 counts should be affirmed. I don't have anything else unless the court has questions for me.
Thank you, Mr. Aranda.
Yes, sir. Thank you.
Okay, Mr. Berman.
2 things. He said that the SOL did not release other claims. He was supposed to draft a release and forward it to me within 1 week. He did not do so. The release would have extinguished every other possible claim under the sun other than the FLSA claim, which can only be released or dismissed with prejudice with court approval. So his argument that we were exposed to other litigation is without merit. He cannot shift his burden of proving an affirmative defense to the plaintiff by hypothesizing about other potential claims that he cannot show even existed. As far as the notice of settlement, not part of the contract, his 3 reminder emails. In fact, at summary judgment, that helps us, because if it was so crystal clear what I had to do, he would not need to remind me. He would simply rest and say, until you do something, there's no deal. So even his own reminders show that he was unsure who had to do what. And no explanation at any time why he didn't send me a release. There's no dispute that he did not do that. And why? If they were not playing a gotcha moment, why not send a release? Why not draft a release and send it over and say, this is the terms, and you need to do court approval within however many days. Again, that's not done. So this was a gotcha. And now in the lower court, he files a lot of things, but doesn't file the federal complaint, which would clearly show that the claims were, quote, time barred. And so we think that, again, this is a summary judgment. We have asked for a jury trial. The terms of this agreement are still, again, we're down to 2 emails, and we're putting a lot of emphasis on 2 emails, but those are the only 2 emails. The 15-day after court approval is a payment provision. And so the question is, did I have the sole burden to do it? Did he? What could I approve if there was no settlement agreement? I don't know what terms he would have wanted. Until he puts that in front of me, there's nothing to approve. So I think, again, at summary judgment, everything has to be viewed in the light most favorable to the plaintiff, unless the facts are so crystallized that it becomes a pure question of law. Summary judgment should be reversed. And that's where we are. We're wondering about what other claims could have been filed. Why wouldn't the release have extinguished a so-called minimum wage claim, which under Florida law doesn't require court approval, or slander claim, or anything else he's talking. 5-year contract. There was no written contract with Ms. Myers. It's a 4-year. So he can't even suggest that. So again, I think for summary judgment, we're still wondering, gee, why didn't he? Is that a repudiation that he didn't send me a release? Does that not cancel my duty to prepare a motion to approval? What do you approve? An email? I mean, it's to me, there are issues of fact and defenses that he cannot prevail on without putting forward evidence, undisputed evidence, and he did not do that. So we would ask you to reverse, send it back for trial.
Okay, thank you, Mr. Berman. Thank you both very much. Court will be in recess for 15 minutes, which by my computer clock here says 11:30.
Thank you.